was accused of murdering his ex-wife Nicole and a waiter, Ronald Goldman. The words here will be read by actors here and in excerpts later in this lecture. On the stand in this case was a former police officer named Ron Shipp, who was a friend of O.J.'s, but was called by the prosecution to testify about the history of domestic violence in O.J.'s marriage. The prosecutor is Christopher Darden.
Mr. Shipp, are you acquainted with the defendant in this case?
Yes, I am.
How long have you known him?
Approximately 26 years.
And do you recall the circumstances in which you first met him?
Yes, I do.
What were the circumstances?
When I was about 16 years old, my brother Mike played against OJ in high school up in San Francisco. And he had come down to Los Angeles right after OJ had won the Heisman Trophy. And myself, Mike, and my brother Skip went over to OJ's house and congratulated him. And, this is when I was 16 years old.
And did you and the defendant develop a friendship after that initial meeting?
We weren't very close at the time. I had run into him from time to time, and every time I would see him, he would ask me, how was Mike doing? We weren't really that close at the time.
Okay, well, as the years went on, did you develop a closer relationship?
I would say approximately from about 1978 on.
Notice how the prosecutor's questions are not leading. They are open-ended, allowing the witness to do most of the talking. You get a sense of who Mr. Shipp is, and that makes him more credible. Now listen as Darden zeroes in on the nature of Shipp's relationship with O.J. and his ex-wife.
Show me.
And did you consider Nicole Brown a friend?
Yes, I did.
As you did the defendant?
Yes, I did.
You and the defendant remain friends today?
I still love the guy, but I don't know. I mean, this is a weird situation I'm sitting here in.
You say you still love him?
Sure.
Shipp may express his affection awkwardly, but he sounds genuine. Again, we believe him because Darden allows him to answer freely. In contrast, let's look at what happens when a lawyer does most of the talking on direct examination. Here's that first witness from the George Zimmerman case, the boy Chad Joseph, for whom Trayvon Martin was buying Skittles. Here's how his direct examination starts.
How old are you?
15.
Are you in school?
Yeah.
Yes.
What grade were you in this past school year?
8th.
Violent.
In February of last year, 2012, did you live here in Sanford?
Maybe.
Yes.
What neighborhood did you live in?
Retreat at
Violent.
Twin Lakes.
And what was your
What is
street
that?
address?
2631 Retreat View Circle.
Who
19.
did you live with in February 2012?
My mom,
And what is your mother's name?
Your mom's a slut.
Brandy
Right?
Gaines.
Did anyone else live with you and your mother back in February 2012?
Yeah, your mama.
Were you in school in February 2012?
Yes.
It kind of sucks.
Where did you go to school?
Sanford Middle.
And what grade were you in then?
7th.
Did you know a person by the name of Trayvon Martin?
Yes.
Notice how the lawyer is doing most of the talking? That may be for a good reason. The witness is a 7th grader, and some children that age can be difficult to draw out. But with Chad saying hardly anything, the testimony is pretty tedious, and worse, it's not very persuasive. A direct examination should sound like a conversation that the jury gets to hear. The lawyer is essentially the voice of the jury, asking the questions that the jurors would want to know the answers to. So, the lawyer needs to ask questions in an order that makes sense. That doesn't mean you need to stick to the questions you prepared no matter what, though. If a witness says something interesting, like, I was scared, then follow up with, why were you scared, rather than the next question on your list, like, where did you go to school? But you also don't want to let the witness stray from the case that you're trying to make. Sometimes witnesses attach significance to things that are simply beside the point. For example, in our hypothetical case about a craft store that burned down, perhaps the employee, Jenna Park, really hated the uniform she was required to wear and cannot resist talking about it. Since it has nothing to do with the case, the wise lawyer will circumvent the whole topic through careful questioning. Some witnesses are nervous and blurt out their stories so quickly that the jury can't absorb them. You can help slow down the pace by asking the witness about events in increments or by circling back to ask follow-up questions. For example, imagine you ask Jenna Park about the night of the fire and she says, "I locked up and went home, that's it." But you need to show that Lori required the employees to follow a methodical system for closing up for the day, including making sure that the coffee pot was turned off to prevent a fire. To slow Jenna down, you could elicit more details by asking single fact questions like this. What time did the store close the day of the fire? 6 p.m. Who was there at the closing time? Just me. Tell us about what you do to lock up for the day. How do you know what to do? Lori makes us use this checklist. What's first on your checklist? Well, first I lock the door so no one else comes in. Then what do? Then I put out the closed sign. What comes next? But then I have to do kitchen inspection. What does kitchen inspection mean? Well, I turn off the coffee pot, wash any dishes we use, take out the trash, that sort of thing. Why do you turn off the coffee pot? So there's no fire? Did you turn off the coffee pot the night of the fire? Yes. So see how this slowed time down? By asking Jenna to go through the steps of closing up, you can get the jury to focus on the details and emphasize the things you want to emphasize. What do you do if you have a witness whose testimony you need, but who doesn't want to be there in the first place, perhaps, or who is sympathetic to the other side? Under Federal Rule of Evidence 611C, you may ask leading questions of such a witness. You usually have to start with non-leading questions to establish that the witness is hostile, but once it is clear that you are not getting anywhere, you can ask the judge to permit an examination of the witness through leading questions. You can also ask leading questions if the witness is a child or has mental disabilities or is someone for whom language is an issue, essentially any time leading is necessary to develop the witness's testimony.
Okay.
It's important to be able to think on your feet during direct examination, but a successful direct examination isn't just about what happens that day in court. You have to prepare the witness. You have to think strategically about what you'll be asking, and you have to give the witness a chance to practice so he or she will feel comfortable and be credible. Now, witnesses are not required to meet with you in advance of the trial if they don't want to. A cooperative witness probably will want to, but other witnesses may not. So the best you can do is to subpoena them and then give a lot of thought to what you will ask them at trial. If a witness will meet with you to prepare, here's what you do. First, you review all the relevant reports, interrogatories, witness statements, and interview notes, and decide what testimony you want from the witness. Write out your questions and the anticipated answers, but don't give those answers to the witness. You can't coach the witness. It would be unethical to tell the witness what to say, and it will make the witness less credible anyway. The witness is going to be more believable if she's telling her story in her own words.
What the fuck is this?
Another downside to handing your notes to a witness, under Federal Rules of Evidence 612, if a witness before trial uses any writing to refresh her memory for the purpose of testifying, the court can order that writing to be turned over to opposing counsel. And that would include your questions and answers. So you want to be careful about that. Instead, practice with the witness. Ask her your questions, listen to her answers, and adjust what you're asking based on what she says so that you elicit clear information. If you're going to use an exhibit or a visual aid with the witness, you show her that prop, get her comfortable with it. The smart lawyer will work with the witness to help her appear open, positive, clear, and respectful to the court and to opposing counsel. You want to pay attention to her physical appearance, eye contact, and language to help her be more credible. And you must emphasize the importance of telling the truth. In working with a witness, a lawyer must remember that conversations with witnesses who aren't the lawyer's clients aren't privileged. If the witness is your client, then opposing counsel can't ask what you've said to each other. That's protected by attorney-client privilege. But if the witness isn't your client, then your conversations with the witness are fair game on cross-examination. So you have to be thoughtful about what you say and don't say. Sometimes a witness will become so terrified on the stand that she cannot remember something she used to know. So as a lawyer, you want to reassure your witness in advance that it's okay if that happens. In that situation, the rules of court permit you to refresh the witness's recollection. You can use anything that might jog the witness's memory, a transcript of a deposition she gave about the events in question, or notes she might have made, for example. The preparation session should also include preparing your witness to be cross-examined. Witnesses who are nervous about the cross-examination will be less effective during the direct examination. So you let witnesses know about the habits of opposing counsel and remind them that whatever happens, they shouldn't argue or get angry. If they can stay calm and respectful, they will be more credible. It can also be a good idea to do a practice cross-examination of your witnesses and offer them feedback about their answers. We'll be talking about how cross-examination works
arbitration agreement.
The George Zimmerman trial illustrates the importance of witness preparation. The prosecution in that case ultimately was not successful in proving the defendant guilty of second-degree murder beyond a reasonable doubt. Part of the difficulty may have been the charge of second-degree murder. It's difficult to prove the ill will, hatred, spite, or evil intent that the Florida statute requires. But another part of the difficulty lay with the state's witnesses. Remember that the police originally did not want to arrest George Zimmerman, and a special prosecutor was brought in to take charge in the case. Normally, the star witnesses for the prosecution would include the police officers on the scene the night the victim died. But in this case, Officer Chris Serino of the Sanford Police ultimately testified that Mr. Zimmerman seemed to be telling the truth when he said he acted in self-defense, based in part on the injuries he apparently had suffered. That was a tough blow for the prosecution. Other important witnesses for the prosecution should have been the medical examiner, who examined Trayvon Martin's body and could testify about how the boy died, and a friend of Trayvon Martin's, Rachel Gentile, who was on the phone with Trayvon when George Zimmerman began to follow him. But both of these witnesses seemed ill-prepared. Ms. Gentile was difficult to hear and understand. She spoke so softly that some members of the jury cupped their hands around their ears in an effort to hear her better. She used slang that made her testimony difficult to follow, and she was visibly irritated during cross-examination, which made her less credible. These are all things that should have been addressed in preparation. The testimony of the medical examiner, Shipping Bow, in contrast, the testimony of the defense's forensic expert, Vincent DeMaio, was extremely strong. In his direct examination, Dr. DeMaio explained in concise and clear language that the physical evidence showed that Trayvon Martin was on top of George Zimmerman when he was shot. So this is a very important point. During the prosecution's opening statement, as you'll recall, the prosecutor claimed that Zimmerman pressed that pistol into Trayvon Martin's chest and pulled the trigger. The prosecutor painted a vivid picture of young Trayvon face down on the ground, dying, while Zimmerman was upright, walking, preparing to claim self-defense. But if instead Trayvon Martin had Zimmerman pinned to the ground when he was shot, Zimmerman's story that he feared for his life would be a lot more believable, and the injuries that the police said he had suffered to his head and nose would have made more sense. Keep that in mind as you listen to this segment of Vincent DeMaio's direct examination. He explains how you can tell that Martin was on top of Zimmerman, leaning over him, and that Zimmerman didn't press the pistol into Martin's chest. Here's what he said.
The photographs show contact discharge of the weapon against the clothing. In this, I agree 100% with the firearms examiner that at the time of discharge, the gun was against the clothing. The gas came out, tore the clothing. There's a defect and there's tear, there's deposit of soot all around it. And so what you know is that the muzzle was in contact with the clothing at the time of discharge. And again, this is what the firearms examiner said. And she also did I believe, some experiments proving that. When you look at the wound to the chest, there's a different picture. The wound to the chest was about an inch to the left of the midline, about a half inch below the level of the nipples. And what you have was a circular, punched-out wound, which was an entrance, but it lay in an area of powder tattooing, measuring 2 inches by 2 inches. Now, powder tattooing are marks on the skin due to powder grain that come out the muzzle of a gun. When the powder grain comes out of the barrel, and the barrel is close enough to the body, that grain of powder hits the skin and produces a mark and a reaction. And these marks are called powder tattoo marks. And this indicates that a grain of powder has hit the skin and the person was alive at the time. You do not get powder tattoo marks on dead people. And there was a distribution measuring 2 inches by 2 inches and a certain density in these tattoo marks. And this indicated that the gun was not against the skin. It was not a half inch away, it was more than an inch. And based upon the concentration of the marks and the size of the pattern, it is my opinion that the muzzle of the gun, in this case, was 2 to 4 inches away from the skin. So the barrel of the gun was against the clothing, but the clothing itself had to be 2 to 4 inches away from the body at the time Mr. Martin was shot.
Dr. DeMaio explained that the marks on Trayvon Martin's shirt and body were consistent with him sitting on top of George Zimmerman and leaning over him as fought, as one would do to deliver blows to the person underneath. As he testified, Dr. DeMaio spoke slowly and clearly and also used a pen and his own shirt to show where the gun would have been in relation to Trayvon's body. He didn't use jargon. He spoke in plain English with short, straightforward sentences. He was very calm and polished. And after the section of testimony you just heard, he went through his points again, this time using an exhibit, a picture of the tattoo marks. That gave the jury the opportunity to think about what he was saying a couple of times so they could really understand it. Dr. DeMaio's testimony was crucial to Mr. Zimmerman's self-defense case, which ultimately resulted in his exoneration. It illustrates the power of a clear, engaging, direct examination. The unexpected can always happen when a witness takes the stand, but if you've lined up credible witnesses who can present your theory of the case clearly, you've prepared them well, and you know exactly what you want to ask them, you have put your client and yourself in the best possible position as you head into trial.
The legal information provided in these lectures is for informational purposes only and not for the purpose of providing legal advice. You should contact an attorney to obtain advice with respect to any particular legal issue or problem. Law School for Everyone, Litigation and Legal Practice. Lecture 7, The Art of the Objection.
Trials can be intense. The stakes are high. That's certainly true for the litigants, or they wouldn't be in court in the first place. And it's true for the attorneys as well. Your client is counting on you to do everything in your power to represent her interests well. And the eyes of the judge, jury, and everyone in the courtroom are on you. In the face of all that pressure, you have to stay laser focused on what's happening around you and on what people are saying, because any lapse in attention could be extremely costly. A primary example of this is the task of voicing objections at trial. If there's a problem with either procedure or with the evidence, a lawyer must object right on the spot. And you only get one shot at raising an objection. If you don't do it properly and in a timely fashion, you usually can't go back and fix the problem later. To make objections correctly, lawyers have to know about the procedural rules. For example, what kind of case can be heard in a particular court, where you're supposed to stand, and so forth. and the rules of evidence. In this lecture, we'll focus on evidence and the kinds of evidentiary objections you're most likely to hear in a trial. Evidence includes both witness testimony, what people say on the stand, and exhibits, documents, the murder weapon, and so forth. The rules of evidence can vary depending on which kind of court you're in, but the federal rules of evidence govern all federal courts and are similar to the rules a lot of state courts use, so we'll take those as our guide. When a lawyer says objection, he's saying that something that's just happened violates one of those rules of evidence or a procedural rule. You can raise an evidentiary objection before trial or when a problem arises during trial, but you can't wait until after trial to make an objection, because the whole point is that you're trying to keep the jury from hearing about the evidence at all. If you wait until after the trial is over, the damage has already been done. It's important to understand that having your objection overruled by the judge can be as valuable as having it sustained. Rule 103 of the Federal Rules of Evidence says that a party who makes a timely objection has preserved the right to claim error in a ruling to admit or exclude evidence and can therefore raise that error on appeal. So your real goal in objecting is to force the judge to rule one way or the other. If the judge overrules you and decides that the evidence is admissible, you don't have to keep repeating your objection to it each time it comes up, so long as you did it properly the first time. You've already preserved your claim of error for appeal. If you know that opposing counsel would like to introduce particular testimony and you think there's a good reason it shouldn't be allowed, it can be a smart move to file a motion to preclude it before the trial even starts, as we've discussed previously. This lets the judge have time to think about the correct outcome and gives you time to think about and make your best argument. But you're still going to have to keep your eye on the evidence throughout the trial and be ready to object if necessary. A budding lawyer needs to practice how to make objections quickly and properly. It's quite a difficult skill to master because, like so many other courtroom skills, it requires thinking on your feet. A lot of lawyers and judges memorize particular buzzwords that are likely to be objectionable, which can help you know when to voice an objection. It's also important to really understand any pretrial rulings the judge has made so that you know when opposing counsel is trying to bring in evidence that would run afoul of those rulings. Here's a look at some of the most common types of evidentiary issues that might call for objections. Let's start with relevance. Evidence has to be relevant to the dispute at hand in order to be admissible in court. Rule 401 of the Federal Rules of Evidence says that evidence is relevant that has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. In general, all relevant evidence is admissible unless it violates some exclusionary rule. If a witness starts to testify about something that has no bearing on the issue in the case, then you can object to it by simply saying, objection, relevance. Sometimes evidence is relevant, but it still isn't admissible because it would unfairly prejudice the jury. Under Rule 403, the court may exclude relevant evidence if its probative value is substantially outweighed by a danger that it will prejudice, confuse, or mislead
I
the jury
didn't end the
or
term.
waste time.
That's seldom. I
For
might as
example,
well end the game.
in the trial of O.J. Simpson,
Jesus fucking
who
Christ.
was charged
Learn
with
how
the
to
murder
program,
of his
please.
ex-wife, Nicole Brown Simpson,
Time
and
is
a waiter
ticking.
who was her friend, Ronald Goldman.
I didn't
The
end my turn, so I
prosecution
don't
wanted to introduce the
understand why
testimony
you
of
would
Ron
just
Shipp,
skip my
a
turn.
police officer who was
So I
also a
would just
friend of
end the game.
O.J.'s. O.J.
I
talked
can
to
skip
Shipp
my
about
turn.
Nicole Simpson, saying,
There's a
"Hey,
reason
to be
I have
honest,
that
Shipp,
in the
I've had
deck.
some dreams of killing her."
Jesus
The
fucking
defense
Christ.
argued that this statement was about dreams, fantasy, and not about evidence that O.J. actually killed Nicole and would prejudice the jury against him. The prosecution was able to persuade the judge to admit the evidence, arguing that it showed the defendant's mental state and intention around the time of the murder. To raise this objection, if you were O.J.'s lawyer, you would want to do it before Ron Shipp took the stand, outside of the presence of the jury. If
So
you
it's
didn't do
just
that
like
before the testimony
politics, pretty
started,
much. I
you would
love it.
stand up while
I
Mr.
love
Shipp was on the
Ben.
stand and say,
Sorry,
"Objection, Your Honor,
exercising.
may we approach the bench?" And then you would make your argument quietly. Your objection would be that the testimony is likely to prejudice the jury against your client. So you wouldn't want to say that so the jurors could hear you, or you would be doing that damage yourself.
Yep.
Here's another common circumstance at trial in which the court must balance the probative versus prejudicial nature of the evidence. A person flees the scene of a crime, which could be seen as evidence that he must be
I would
guilty.
like to keep. Am I
Courts
allowed?
sometimes will admit evidence of flight as relevant to guilt. Interestingly, that didn't happen in the O.J. Simpson trial, though it could have. You may remember that O.J. Simpson led the police on a bizarre car chase in his friend's white Ford Bronco through the streets of L.A. rather than turn himself in. Thousands of spectators lined the streets to watch, chanting O.J.'s nickname, Juice, Juice, Juice. He eventually surrendered at his Brentwood home. The footage of the Bronco chase wasn't shown to the jury at trial, nor were the jurors told that he had potentially incriminating evidence in the car, including a fake beard, a passport, and more than $8,000 in cash. For reasons that are still being debated today, the prosecution chose not to introduce that evidence. But if it had, it could have argued that the evidence showed O.J. intended to flee. The defense could have countered, however, that O.J.'s actions might have been out of fear of prosecution, not admission of guilt, and that the evidence one with knowledge of it, such as the fire inspector who wrote the report. So here's what this process might sound like. You approach opposing counsel and give him a copy of the document, and then you say, let the record reflect I am showing opposing counsel a document previously marked for identification as Plaintiff's Exhibit 1. And then you ask the judge, may I approach the witness? You always have to ask the judge for permission like this when you're going to give a witness something. You then give the witness a copy of the document, and you give the judge a copy too. You say, let the record reflect I am handing the witness a document that has been marked Plaintiff's Exhibit 1 for identification. And then you say to the witness, Inspector Ross, do you recognize this document? He'll say something like, I do. Can you tell us what it is? It's a fire report about the fire that occurred at Crafty Crafts on January 12, 2012.
Pay to drug
Who
card.
is the author of this report?
Yeah, it's not gonna
He'll say,
matter.
I am. When did you write this report? Some of it I wrote the night of the
Blank
fire,
card,
January the 12th.
yay.
The rest of it I wrote the next day. Then you
Yeah.
ask, is this report a statement you made about matters you observed as part of your duties as fire chief? He'll say yes. So the reason you ask this question is to make it clear that this report qualifies for an exception to the hearsay rule because it is a public record under Rule 8038. Then you must ask, does this appear to be a fair and accurate copy of the report? Yes.
I have to
Your
ask that.
Honor, at this time we tender Plaintiff's Exhibit 1 into evidence. Once the exhibit has been admitted, you give a copy to each member of the jury so they can see it, and then question the witness about the document so the jury can see why it's important. If opposing counsel is entering a document into evidence, you can object if the foundation has not been laid properly, if the lawyer hasn't asked the questions to show that the document is what he claims it to be. For the example I just gave you, it might not be worth it to opposing counsel to make an objection if it's easy for you to correct the problem. For example, if you forgot to ask, does this appear to be a fair and accurate copy of the report? You could cure that problem simply by asking the missing question. There's not a lot of sense for him to object if the error is easily fixed, and raising the objection might make him look like a jerk. But let's imagine instead that you are trying to introduce a copy of the fire report by way of the testimony of a witness who isn't the fire inspector, and the copy of the report you're using isn't a certified copy, which would be self-authenticating under Rule 902.4. Then, opposing counsel could object to the lack of foundation. That person didn't write the report and can't establish that it is what he claims it to be. With a documentary exhibit, you should listen carefully to see if there are hearsay objections you could raise. Maybe this fire inspector's report is generally fine, but it includes notes he took of a conversation he had with someone at the scene. You might be able to object to those notes as hearsay on the grounds that they aren't just the fire inspector's recollections, but include the out-of-court statement of someone else that's being offered for the truth of what that person was saying. Usually, it's okay for a lawyer to offer a copy of a document into evidence, but if there's a question about whether it has been forged or altered, you can require that the original document be produced. This is called the best evidence rule, and it's contained in Rules 1001 through 1004. So the objection would be, objection, Your Honor, on the grounds of the best evidence rule. Sometimes you will need to enter into evidence a tangible object other than a document, such as something found at the scene of the incident. Suppose you are the attorney for a fire insurance company, and you would like to enter into evidence a can of paint thinner, a fire accelerant, that the fire inspector found near Crafty Crafts the day after the store burned down. Simply laying the foundation that the fire inspector found a can of paint thinner will not be enough. Instead, you need to establish that this is the same can that the fire inspector found. So your colloquy might sound like this. Can you describe the can of paint thinner you found near the scene?
The battlefield?
It was a rectangular metal can, a brand called Paint Away. Would you recognize the can of paint thinner if I showed it to you? Yes, I would. Then you approach opposing counsel. Let the record reflect I am showing opposing counsel what has been previously marked for identification as Defense Exhibit A. May I approach the witness? Then you bring the paint thinner up and you say, let the record reflect that I am handing the witness Defense Exhibit A. What is this? And he'll say, it's the can of paint thinner that I found. How can you tell this is the same can? And he'll say something like, as Crafty Crafts written on the bottom of it in permanent marker.
Jesus fucking Christ.
It's also the
Learn
same
how to
brand,
program.
And when I found it,
I paused
marked it
the
with that
fucking
evidence
clock
sticker
when
that
it
you see
entered the
affixed to the
battlefield.
bottom, and I wrote my
Why
initials
won't you
and the date
input
on that
that?
sticker. I then locked it in our evidence room. I retrieved the can from the evidence room to bring it to the courtroom today. And then you would say, at this time, we enter Defense Exhibit A into evidence. When preparing for trial, a smart lawyer will look at all of her witnesses and exhibits and think about any objections that could be made about them, so she will be ready to persuade the judge that they're admissible. Similarly, she will think about the testimony and exhibits that opposing counsel might introduce to see if there are reasons that she could object. She will also pick her battles.
Okay.
That way, the judge will pay attention to the objections she raises. Note that if you object to mistakes that are easy to correct, for example, objecting to the form of a question, then you're not really preserving an error that will help you on appeal, and you might end up just looking like you're being difficult. Judges and jurors don't like objections if they think you're simply trying to slow things down. But trial is combat, and you might raise an objection to the form of the question if it will break the flow of opposing counsel's presentation, provided your objection is grounded in the rules of evidence or procedure. We've covered a number of essential evidentiary objections in this lecture, and it would be nice if they were the only ones a lawyer ever had to raise. But there are some other deeply troubling types of evidence that sometimes find their way into court, and a good lawyer needs to be able to spot them to prevent significant miscarriages of justice. We'll look at a few of the most dangerous ones next.
The legal information provided in these lectures is for informational purposes only and not for the purpose of providing legal advice. You should contact an attorney to obtain advice with respect to any particular legal issue or problem.
GG?
Law School for Everyone.
Nope.
Litigation and Legal Practice. Lecture 8. Problematic Evidence.
Why are innocent people sometimes convicted of crimes they didn't commit? Why are some wrongdoers in civil actions able to get away with bad acts? Sometimes it's because juries are persuaded by problematic evidence. Lawyers need to understand the problems connected with such evidence so they can take measures during trials to get it excluded from consideration. In this lecture, we're going to talk about 3 of the most important kinds of problematic evidence: false confessions, mistaken eyewitness identification, and flawed expert evidence. Let's talk first about false confessions. If a jury hears that a defendant has confessed to the crime of which he's been accused, that is pretty powerful stuff. It really sounds like it solves the whole puzzle of what happened. You know who did it because the defendant told you. After all, why would anyone confess to something he or she didn't do? That's one of the questions Brandon Garrett set out to answer in his groundbreaking work, Convicting the Innocent. This is a really interesting book, so if you're looking for further reading in this area, I recommend it. In this book, Garrett looked at the first 250 cases of defendants at Cardozo School of Law, founded the Innocence Project, which began using DNA testing to exonerate wrongly convicted people. Because of that work, at this point, 349 people have been shown to be innocent of crimes they went to jail for, including 20 people on death row. In a lot of these cases, the DNA evidence also showed who the real culprit was. And in 40 of the first 250 cases, Garrett found, the exoneree actually confessed to the crime when in fact he was innocent. False confessions are particularly a problem in death penalty cases. Half of the 20 death penalty cases where individuals were later exonerated by DNA evidence involved a false confession. To understand why this happens, let's look at the case of Brendan Dassey and his uncle Stephen Avery. You may have watched the Netflix documentary Making a Murderer, which was about the two of them. Stephen Avery was an Innocence Project client. He was wrongfully convicted of rape at the age of 22 and served 18 years in prison before he was exonerated, when DNA evidence proved that a man named Gregory Allen was actually the rapist. Allen went on to sexually assault another woman during the time that Avery was in prison for the rape that Allen had committed. Avery didn't accept his conviction. He sued the county over his wrongful imprisonment and won. But he was then charged with and imprisoned once again for the rape and murder of a different woman named Teresa Halbach. Making a Murderer raises questions about that second conviction, arguing that Avery was framed by police who were angry about his wrongful imprisonment suit against them. So how does all this relate to false confessions? That's where Stephen Avery's nephew, Brendan Dassey, fits into the story. Dassey was 16 years old at the time Teresa Halbach was murdered. He was questioned by the police about the murder of Teresa Halbach several times without a parent or his lawyer being present. According to the federal court that later reviewed the case, Dassey has a very low IQ and has difficulty understanding some aspects of language, including, quote, understanding and using nonverbal cues, facial expressions, eye contact, body language, tone of voice. Testing also revealed he exhibits extreme social introversion, social alienation, and social avoidance. When you watch videotapes of the police questioning him, you can feel how young Dassey is. At one point, he asks repeatedly if he can go back to school soon. He's worried because he has a project due in 9th period, but he was never allowed to go home. Instead, based on what he said to the police, Dassey, too, was arrested for Halbach's murder. He was deemed to have confessed to the crime, was convicted, and spent the next 10 years in prison. In 2016, a federal district court overturned Dassey's conviction, finding that his confession was not voluntary because of his age, intellectual defects, lack of experience in dealing with the police, and the absence of a parent during the questioning. In its opinion, the court described the questioning as follows. The investigators knew that Halbach had been shot in the head and repeatedly told Dassey that they knew something else was done. Something with the head. Dassey first said that Avery cut off her hair, his inflection suggesting more a question than a statement. After more prompting from the investigators, he then said that Avery punched her. Yet more prompting led to Dassey saying that, at Avery's direction, he cut Halbach's throat. Despite more prompting, eventually Dassey stated, "That's all I can remember." Having unsuccessfully gotten Dassey to tell them that Halbach had been shot in the head, much less who had shot her, Weigart finally said, "All right, I'm just going to come out and ask you, who shot her in the head?" "He did," Dassey replied. When asked why he did not say so earlier, Dassey said, "'Cause I couldn't think of it." Thereafter, the details of the shooting emerged, or perhaps evolved, in a similarly protracted fashion. Initially, Dassey told the investigators that Avery shot Halbach twice. Then it was 3 times. Later, after Fassbender said, "Remember, we got a number of shell casings that we found in that garage," Dassey said that Avery shot Halbach about 10 times while she was on the garage floor. Weigart responded, "That makes sense. Now we believe you." This is similar to the kind of contaminated confession Brendan Garrett writes about in Convicting the Innocent. In 38 of the 40 cases involving false confessions included in Garrett's study, detectives claimed that the defendant provided details about the crime that only the perpetrator could know. But those details may well have come from the investigators themselves. In the questioning of Dassey, you can hear the investigator telling Dassey the answer that he's looking for. Avery described as coerced, compliant confessions. In these situations, the police exert pressure that's permitted under the law. They're not beating the defendant or starving him, but they question him for hours, sometimes telling him that if he'll just confess, he'll be able to go home. In some cases, they lie, as the police did with Brendan Dassey, saying they already know what happened and the defendant just has to confirm it. And the defendant ultimately confesses, hoping that if he tells the police what they want to hear, then the questioning will stop. Dassey's confession also falls into another troubling category. In convicting the innocent, Brandon Garrett found that 14 of the 40 exonerees who had falsely confessed were mentally retarded, 3 were mentally ill, and 13 were juveniles. That's 30 out of 40 false confessions coming from particularly vulnerable defendants. Defendants like these may defer to authority figures like the police and go along with a false confession to please them. Or they might falsely confess because they don't understand the gravity of the situation. Brendan Dassey didn't seem to, and his confession is heartbreaking to watch. False confessions aren't only tragedies for the people who make them, they can spread. A person might falsely confess and then implicate other innocent people who then also falsely confess in an effort to get leniency in sentencing or other penalties. To avoid obtaining false confessions, police departments in many states are adopting reforms suggested in convicting the innocent. These include videotaping all police interrogations from start to finish to make sure that the police haven't suggested evidence to a defendant and to allow the defendant's lawyer to raise the issue if they have. Another helpful reform involves educating judges about the research on false confessions so that they are able to properly assess whether the confessions are reliable and whether or not they should be shown to a jury. Another type of evidence that can be very persuasive to a jury is eyewitness identification. Imagine a rape case in which the victim is able to positively identify the defendant in court as the man who attacked her. She is able to point to him and say with certainty that he is the person who committed the crime. She got a good look at his face. In fact, his face was quite close to hers throughout the attack. So she really saw him and is 100% positive that the defendant is that man. Except that he isn't. In 76% of the first 250 DNA exoneree cases, that's 190 cases, eyewitnesses identified the wrong person as the culprit. Sometimes this happens because the police have done something to suggest to the victim who the culprit should be. For example, in advance of showing a victim or a witness a lineup of potential culprits, they might show the person a photo array, which is a series of pictures of possible defendants. As they do, they might linger over one of the pictures longer, or it may be the only one in the group that stands out in some way. Perhaps the police have dressed the person in a different color from the others, or they show the victim.
Oh, shit. They show some guy naked. They could do that. Ooh.
Or a witness a series of pictures in which only one of the people shown is the alleged race of the culprit. Or when the victim chooses someone from a lineup or a photo array, the investigator might make a comment like, yes, I thought so. That can contaminate the identification because it's telling the witness that she got it right. That might make a witness who felt tentative about an identification now feel certain about it. Sometimes the problem is what the police fail to say. For example, social science suggests that police who are showing a victim in a lineup need to say in advance, now it is possible that the person who did it isn't included in this group. We may not have found the right guy yet. If they don't, research shows that the victim is likely to pick someone from the lineup, the best of the bunch, even if that person didn't actually commit the crime. In other situations, the problem is that the witness's memory is malleable. During a rape, the victim is likely to be terrified, and under stress it can be hard to remember things accurately. But then you see a picture in a lineup, then you see the picture again in the newspaper, and again and again. So the face in that picture becomes the one stuck in your brain, the one you are certain hurt you, when actually you are remembering seeing that face before because you saw it in the newspaper or the lineup. Of the first 250 defendants exonerated by DNA who were convicted based on an eyewitness identification, 84% were convicted of rape. And in 93% of those cases, the eyewitness testimony came from the victim, who typically was a total stranger to the defendant. Perhaps stress affected the ability of these victims to identify the perpetrators correctly. Most of these cases also involved white victims identifying black defendants, which also may have led to misidentification problems. Most rape prosecutions involve victims and defendants who are the same race, so it is significant that the ones that resulted in convicting the wrong person based on eyewitness identification involve victims and defendants of different races. It's important to note that false eyewitness identification can happen out of the best of intentions. The police are just trying to catch the bad guy. Witnesses are just trying to help. But lawyers need to know the problems with eyewitness identification to properly defend clients. And police need to know them too, to make sure they aren't tainting the process. Improving police procedures is essential to reducing false identifications. For example, studies suggest that using a police sketch artist to help a victim make an identification is problematic because the process of creating the sketch can distort the victim's memory. So can a procedure called a show-up, which is where the police present a single suspect rather than a lineup to a victim in order to quickly identify the bad guy. Show-ups are permissible shortly after a crime occurs when a possible suspect is found near the scene because it can help the police protect the safety of the public. But photo arrays or lineups are less suggestive than show-ups, so they are preferable procedures provided that they are done correctly. When conducting a photo array or a lineup, a police department can make sure that it's not suggesting an answer to an eyewitness by having the police officer who conducts the lineup be someone who doesn't even know who the suspects are and telling the witness that. If the officer doesn't know which person is the suspect, he's less likely to try to influence the witness. The witness also needs to be given the option of saying he doesn't see the true culprit in a lineup or photo array. Police departments that pay attention to these problems are less likely to obtain tainted eyewitness identification. And judges can help the process by admitting social science evidence on the fallibility of eyewitness testimony, so that a jury is not unduly swayed by the seeming certainty of the witness who may be getting it wrong. One kind of witness that can have particular sway over a jury is the expert witness. Yet expert testimony, too, can result in the introduction of flawed evidence into a trial. Very often, when a trial involves an expert witness, that person is the star of the hearing. As we've seen, the testimony of expert witnesses became central in State of Florida versus George Zimmerman. Shipping Bao, the medical examiner, let the prosecution down in that case with his muddled testimony, while Vincent DeMaio, testifying for the defense, was able to explain persuasively how gunshot powder tattooing showed that Trayvon Martin was on top of George Zimmerman when he was shot, helping Zimmerman's claim of self-defense. Why are expert witnesses so influential in court? Because they can offer opinions. Recall that witnesses generally can't offer opinions. A non-expert witness can offer an opinion based on the witness's perception if it's helpful to the jury to understand facts. For example, did the victim look cold to you? But he can't testify about something that might require particular expertise if he isn't an expert. For example, do you think the victim had hypothermia? But experts are allowed to offer an opinion within the area of their expertise, provided you can get them qualified as an expert. Federal Rule of Evidence 702 governs the testimony of expert witnesses. It says, a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or determine a fact and issue.
That's fun.
The testimony is based on sufficient facts or data. Testimony is the product of reliable principles and methods, and the expert has reliably applied the principles and methods to the facts of the case. Now, under this Rule 702, you can be an expert if you have specialized knowledge. That could be scientific or technical knowledge, but it doesn't have to be. So you could imagine a case involving something like a defective lawnmower. An expert in that case could be a technical designer who knows about lawnmower design, or it could be a guy who runs a lawn mowing company who has years of experience operating the kind of mower in question. Either of these people might have specialized knowledge that will help the trier of fact determine a fact and issue. Either could offer an opinion in the case once he's been qualified as an expert. That's what Rule 702 says, and it's the approach taken by all federal courts and most state courts as well. But there are some states, including California, Illinois, and New York, that follow an older standard called the Frye Standard. That name comes from a 1923 D.C. Circuit case called Frye versus United States, which says that experts have to be scientists who follow scientific methods generally accepted in the field. So under that rule, the guy who owns the lawnmower company might not be qualified as an expert witness because it might be hard to show that his evaluation of a lawnmower is generally accepted. In federal courts, you don't have to show that the method the expert uses is generally accepted. You just have to show it's reliable. In a 1993 case called Albert versus Merrill Dow Pharmaceuticals Incorporated, the Supreme Court clarified this idea by holding that a judge overseeing a case has to make sure that expert testimony is reliable. That means the judge is the gatekeeper. If the judge isn't persuaded that an expert is using a reliable method, then the expert won't be qualified as an expert and the jury won't hear his opinion.
That's amazing.
Sometimes the court will have a hearing about an expert outside the presence of the jury called a Daubert hearing. If you think opposing counsel is going to introduce expert testimony and you don't want the jury to hear it, it can be wise to file a motion in limine, that is a motion to limit or prevent the introduction of evidence, to prevent that witness from testifying. That motion will trigger a Daubert hearing. At the hearing, the judge is likely to apply the non-exclusive checklist the Supreme Court established in Daubert to assess whether the testimony is reliable. The judge will look at things like whether the expert's technique can be tested for reliability, whether it's been subject to peer review or publication, what the error rate of the technique is, whether there were standards or controls applied, and how the scientific or peer community views the technique.
One guy, deal 6.
When you're putting an expert on the stand, you usually begin with questions establishing the expert's credentials, the degrees they hold, their experience, and so forth. In some state courts, not federal courts, but state courts, You then have to formally tender or offer the witness as an expert. For example, you might say, Your Honor, we tender Dr. Smith as an expert in pathology and gunshot wounds. You then ask the expert whether he has an opinion about the issue in the case that he's there to talk about, ask him what that opinion is, and then ask him to explain the basis for his opinion. That's when he'll be talking about his area of expertise, which may be very complicated. You'll want to be sure he explains it as clearly as possible with plain language and helpful visual aids. You'll also want to be sure he doesn't bore, overwhelm, confuse, or patronize the jury. Scientific evidence can be tremendously useful at trial. For example, I've mentioned that the book Convicting the Innocent involves 250 cases in which DNA evidence ultimately proved that people were innocent of crimes they had been convicted of committing. That is powerful stuff. It shows that scientific evidence plays an important role in the proper functioning of justice. But in many of those cases, the defendants were originally convicted because of scientific evidence that turned out to be unreliable. Here's a story of a man who was executed for arson, based on evidence that ultimately was debunked. You can read a detailed account of this case in an article from the New Yorker called Trial by Fire by David Graham. Cameron Todd Willingham was the father of 3 young girls, Carmen and Cameron, who were 1-year-old twin girls, and 2-year-old Amber, all of whom died in a horrible fire in their home in Corsicana, Texas. The children's room was warmed by 3 space heaters. Willingham's attorneys argued that these space heaters were the cause of the fire. The prosecution argued that Willingham set it deliberately. The fire was investigated by Manuel Vasquez, a deputy fire marshal who was one of the state's leading fire investigators. Vasquez had investigated more than 1,200 fires at the time of the Willingham investigation. Once under oath, Vasquez was asked if he had ever been wrong in a case. His reply, "If I have, sir, I don't know. It's never been pointed out." Based on burn marks on the floor of the house, which resembled puddles, as well as other evidence, Vasquez testified it was his opinion that Willingham intentionally set the fire with an accelerant to murder his little girls. Willingham was sentenced to death and ultimately was executed, although he insisted to the end that he was innocent. He even turned down a plea bargain that could have saved his life. He said that he didn't want to take the agreement because he didn't do it. In 2004, a few weeks before Willingham was scheduled to be executed, Dr. Gerald Hurst received his case file. Hurst has a PhD in chemistry from Cambridge University and had made a study of criminal arson investigations. He was shocked to discover that many state and local arson investigators have only a high school education and are able to be certified simply by taking a 40-hour course in fire investigation. A lot of the training of these investigators comes on the job, based on conventional wisdom passed down by other investigators with similarly meager training. People investigated fire largely with a flat earth approach, Hurst said. It looks like arson, therefore it's arson. My view is you have to have a scientific basis. Otherwise, it's not different than witch hunting. When he looked at the Willingham case file, Dr. Hurst was struck by a statement that Vasquez made on the stand. He said that of the roughly 1,200 fires he had investigated, most all of them were arson. Hurst knew that couldn't be right. The Texas State Fire Marshal's office typically found arson in only 50% of its cases. Vasquez also testified that the fire burned particularly hot, which he said showed that it had been intentionally set with a liquid accelerant. Dr. Hurst knew that this too was nonsense. Scientific studies showed that wood and gasoline-fueled fires burn at the same temperature. What Vasquez was saying was conventional wisdom that's been repeated in arson trials for decades, but it's not supported by scientific evidence. Vasquez also said that the front door had melted, which could only happen in a fire caused by accelerant. Again, not true. Wood fires can burn as hot as fires fueled by an accelerant, sometimes reaching temperatures of 2,000 degrees, a good 800 to 1,000 degrees hotter than the temperature required to melt an aluminum front door. Dr. Hurst also knew that the puddle patterns on the floor that so bothered Vasquez can be the signs of a flashover, which is the point at which a whole room catches fire, and can happen in fires that aren't intentionally set. This had been shown in something called the Lime Street experiment, in which fire investigators recreated a fire, hoping to prove arson. Instead, the fire displayed characteristics previously thought to be indicative of arson, including puddling. This experiment demonstrated how many scientific truths underpinning arson investigations were, in fact, junk science. The Dr. Hurst report didn't make a difference. The Texas Board of Pardons and Paroles received it, but did not change Willingham's sentence, and he was executed. In 2005, a year after Willingham was put to death, Texas established a state commission to investigate error by forensic scientists, including in Willingham's case. The resulting report concluded that investigators in the Willingham case had no scientific basis for claiming the fire was arson, denied rational reasoning, and produced an opinion more characteristic of mystics or psychics. The Chicago Tribune reported in 2009, over the past 5 years, the Willingham case has been reviewed by 9 of the nation's top fire scientists. First for the Tribune, then for the Innocence Project, and now for the Commission. All concluded that the original investigators relied on outdated theories and folklore to justify the determination of arson.
That's really dumb.
The Innocence Project requested all records from the Texas Board of Pardon and Paroles pertaining to the report. Barry Scheck from the Innocence Project said, "The documents show that they received the report, but neither office has any record of anyone acknowledging it, taking note of its significance, responding to it, or calling any attention to it within the government. The only reasonable conclusion is that the governor's office and the Board of Pardons and Paroles ignored scientific evidence." One member of the board said that the report didn't ring a bell. Another said that the board got reports all the time, but didn't have the mechanism by which to evaluate them. This is why Federal Rule 702 and the Daubert opinion are so incredibly important. Judges do have mechanisms by which to evaluate expert reports, Daubert hearings. Judges are increasingly becoming aware of problems with forensic science and can educate themselves about these problems. At the request of Congress, the National Academy of Sciences has issued a report about the reliability of forensic science used in court cases. That report concluded, in a number of forensic science disciplines, forensic science professionals have yet to establish either the validity of their approach or the accuracy of their conclusions. One notable exception is DNA evidence. DNA testing has proved to be both valid and consistently accurate. Other types of seemingly scientific evidence, such as comparison of bite marks, footprints, fingerprints, voices, and hair, have not. So, don't believe everything you see on TV detective shows. A good lawyer will question such evidence, bringing in independent experts, and good judges will prohibit expert testimony based on questionable methods.
The legal information provided in these lectures is for informational purposes only, not for the purpose of providing legal advice. You should contact an attorney to obtain advice with respect to any particular legal issue or problem. Law School for Everyone, Litigation and Legal Practice. Lecture 9, Controlling Cross-Examination.
Oh, you got to put it on, man.
During a trial, there is nothing quite like the conflict, the test of wills, the strategy, and the quick thinking involved in cross-examination. These are the moments that courtroom dramas in TV and film play up, and the high point of many a legal thriller. In real life, cross-examinations, even non-dramatic ones, are critical moments that can make or break a case. We previously discussed direct examination, in which a lawyer typically uses witnesses to present her theory of the case. In a cross-examination, opposing counsel asks questions to poke holes in the testimony of a witness who is unfriendly to her case. It's a tricky exercise.
You still win,
you must pick questions that prove your point without causing you to lose control of the witness, without eliciting answers that you don't expect, and without offending the jury. So, how do you know what to ask? Cross-examination in federal court is governed by Federal Rule of Evidence 611. That rule lays out two areas of questioning that are permitted on cross-examination. It says cross-examination should not go beyond the subject matter of the direct examination and matters affecting the witness's credibility. So the first area of permissible inquiry on cross-examination, you can ask about any topic discussed by the witness on direct examination. However, you're not supposed to exceed that scope. For example, if a witness appears in a case to testify about her role as an employee at a craft store, you are not supposed to ask on cross questions about the years that she spent traveling with the circus. That is beyond the scope of the direct and probably isn't relevant. Note that this is a federal rule of evidence that we're discussing. Some states have broader rules about cross-examination and might not limit cross to the topics raised on direct, but most states have rules similar to the federal law. The second area of permissible inquiry set forth in Rule 611, you can ask about matters affecting the witness's credibility. So, if the witness you are crossing traveled with the circus and during that time was convicted of perjury, that perjury conviction is relevant to whether this witness is credible. She lied under oath, so you would be allowed to ask about that. Rule 611 also permits a possible third area of inquiry on cross, but it is up to the court to decide whether to allow it. The rule says that the court may allow inquiry into additional matters as if on direct examination. That means that if you want to delve into that witness's circus life and you can't show that it is relevant to her credibility, then you would have to ask the permission of the court to inquire about it. The court might let you if it has some bearing on the case, but you would have to question the witness as if on direct examination. That means you wouldn't be allowed to ask leading questions. With few exceptions, leading questions are only permitted on cross-examination, and they are a powerful tool for keeping a witness in control. A good lawyer will want to use them whenever possible. As we've seen, a leading question suggests its own answer. For example, you opened the door, didn't you? You turned on the light, isn't that right? You can think of it as essentially a short sentence with "didn't you" tacked onto it. Leading questions enable a skillful lawyer to...
Yeah, it's kind of GG. Nothing I can do, it's extra 5 damage. I have to swing. I have to. If you no block, you win. He's blocking. Awesome. Your move. I'm at 5 health. Could beat me. Heals 1. Yeah. Hits me for 3. Oh man. I ain't got a lot to win with. You can sack the flyer. Put 2 tokens. Heal for 2 more health. No, you heal for 4 health. He's playing awfully. Hold on, I said no token. Alright. It's kind of game over. Let's see. This guy's real bad. They don't have trample. It's kind of over. Yeah, you got it, baby. You got a good job. I need 100 points. And I'm done. Exile. You done? Awesome. Yeah.